So hi, I'm Sarthak,
Hi.
and here is with me Lavanya and Akshat Agrawal. So this podcast is primarily to discuss the recent marriage equality judgment, and given that you've written extensively on LGBTQ plus inclusion within Indian family law, so we wanted you to come over and have a chat with us. Would you want to introduce
Yeah.
yourself before we get into the
Yeah. Yeah. Thank you for having me for this podcast. Yeah, I'm Akshat Agrawal. I graduated from NLS in 2017, which is really long back now. I'm currently doing a doctoral degree at Yale Law School, and I largely work on the legal regulation of the family from comparative perspectives. Yeah.
Okay, so we'll jump into the questions then. Um,
Yeah.
so for those watching the podcast and who haven't had the time to read the judgment, could you probably give us a little bit of context around what the court's holding is, primarily on whether queer couples have a right to marry, whether there is a right to marry, the right to enter into civil unions, and the court's discussion on the limits of court's power and separation of powers.
Yeah. Thank you for that. So essentially, the decision in Suprio was about the recognition of marriage equality in Indian family law, and the petitioners had challenged the secular family law in India, which is the Special Marriage Act, as well as other family laws, including the Hindu Marriage Act as well. But at the very outset, the court restricted its decision to secular family law. Essentially, what the court held that there is no right to marry under Indian constitutional law. And moreover, it also held that the gendered provisions of the secular marriage law, that is the Special Marriage Act, are not unconstitutional. To just give you some background on Indian family law comprises both secular family law as well as personal law, which are religious identity based personal laws. And largely, these laws are highly interconnected. And there's a long history in India's LGBT rights movement to focus on the secular family law to avoid sort of conflicts with religious freedoms that would naturally occur if you were to focus on religious-based personal laws, which is why they had focused on the secular law, that is the Special Marriage Act here. But the court held that neither there was a right to marry, nor are the provisions of the secular marriage law, nor did it hold the provisions of the secular marriage law unconstitutional. Now, in these 2 points, so this was heard by a five-judge bench of the court. All the five judges agreed on these 2 points. But on the other points, there were divergences. So minority of the court, there is two judges of the court, did hold that there is a right to civil unions. Now, whatever that means is unclear even in the minority decision, but they did say that the Indian Constitution does recognize the right to civil unions, with which the majority obviously disagreed. Similarly, the minority also held that there is a right to joint adoption, which again the majority disagreed. So in sum and substance, the decision did not really hold anything really. It held that there is neither a right to marry, nor are the provisions of the SMA unconstitutional, nor is there a right to civil unions, nor is there a right to joint adoption. What it did clarify was that transgender persons have a right to marry as long as those relationships are within the heterosexual binary, which is already the position of law before the case went to court. So in doing that, the court doesn't say anything new. This was already happening, and High Court had already given these decisions. So that's probably a summary of what the court held in the case.
Lavanya, do you want to take it from here? Yeah.
Yeah, yeah. Thank you for your response, Akshat. So I actually wanted to ask you, in your work, you have written about being hopeful that the court will use Article 14 to make space for queer couples within the law, right? However, Justice Bhatt says that the goal of the Special Marriage Act was to facilitate interfaith marriages and
Yeah,
same-sex marriages remained prohibited when it came into
yeah.
force. The question of under-inclusion, according to him, does not arise because the law was not supposed to make space for queer persons. How would you like to
Yeah.
respond to that?
I mean, I think the response is within the decision, right? I mean, Justice Call's opinion focuses on Article 14 and 15 as potential equality arguments to hold gendered provisions unconstitutional. And I think anybody who applies an equality analysis would understand that you can challenge the equality of laws, challenge whether laws are discriminatory or not discriminatory based on changes in jurisprudence, right? I mean, sexual orientation discrimination wasn't even recognized at the time the Special Marriage Act was enacted. I mean, that's something that the courts have interpreted as part of the Constitution in decisions like Naftej and Nalsa, right? So those are new parts of the equality doctrine, which I think the majority in this case just refuses to apply in these cases. So I mean, I wouldn't. I mean, I think there are two things, right? We as students of law, we invest ourselves in doctrine and in trying to understand how doctrine is applicable to certain cases and how we can make new doctrinal arguments. But like, what is interesting in this case is how they just refuse to apply doctrine which the court has previously recognized, right? So I wonder whether the most interesting parts of this case are in discussing the doctrine in any case, because we all know that they could have developed some other understanding of doctrine to have reached a different outcome. So really, I mean, that's not something I would be very, I mean, this is an argument you can very easily respond to, because you can argue that I mean, equality analysis would require you to judge whether legislations today are discriminating or not discriminating against anyone. And there are new parts of the equality doctrine, the test of manifest arbitrariness, or the test of, we have gone beyond the test of classification in our jurisprudence, yet the court continues with the test of classification in this case, which is again an interesting choice that it makes. So I mean, I mean, obviously that's an argument that Justice Bhatt makes, but I wouldn't sort of, that's not something. It's either neither inconsistent with the court's prior jurisprudence, nor does it make any sense given what the court has decided in previous cases. So I mean, I think a lot of you can understand the court's decision as a decision of forgetting and inconsistency, because a lot of what it has done in the past it simply doesn't do in this case. So I wouldn't think a lot about those arguments really. And I think what's interesting again is what is absent, right? So a lot of prior cases are focused on, say, dignity, which the court doesn't even discuss in this case. And there are so many decisions in previous years, common cause, even Naftej, which discuss dignity in a lot of detail, which is not something that even comes up in these decisions. And again, what's interesting is, and then we can talk a little more about this later, is the relationship between constitutional law and family law, which keeps coming up in this case. But perhaps you can get to it in a minute. Yeah.
I think that's a very good quote. This is a decision of forgetting. But yeah, so picking off from there, so in the US, in Obergefell, if you look at Obergefell, what they do there is they use equality and liberty to sort of arrive at a right to marry, and the judges do that very well there. But in India, the petitioners did make those arguments about liberty and equality. The court also discusses that to a good extent, but it ends by saying that this court cannot use liberty and equality to hold that the state should recognize civil unions, because that goes beyond its power or its sphere of operation. But we've also looked at the court giving decisions like Vishakha and laying down guidelines. So how do you think that the fear of the court stepping its boundaries is well founded, or do you think that it just creates an atmosphere of apprehension when it comes to adjudication in queer rights in India?
Yeah, I think it's hard to understand. As in, I mean, there can be various ways of understanding the court's decision, right? I mean, what is interesting is that at least the Supreme Court has come under a lot of critique in recent times for being extremely deferential to the executive and not really taking up civil rights issues. But perhaps one sort of exception to that sort of critique was its jurisprudence on gender and sexuality, where the court had really given a lot of progressive decisions in recent years. And perhaps Supreme is like a break in that sort of trend, right? Because it's the first time where it has given a not progressive decision in gender sexuality. And I mean, there could be a lot of ways of sort of understanding that. I mean, one reason perhaps could be that in this case, the government did oppose this decision as opposed to sort of decriminalization where the government was supporting it. And the court was at a time when, politics is so dominant by one political party and the government is opposing it, the court was perhaps wary of interbranch conflict. It didn't really want to sort of, fight with the executive right now, especially considering, and this goes back to the second thing, right? Especially considering family law, which is particularly complicated. So it's also about, this case was not merely, it was about queer rights, but it was also about Indian family law, which itself is extremely complex and includes both religious-based personal laws, includes secular family laws. And ultimately the petitioners made a lot of argument for the court was not merely, the decision was not merely about marriage as well, right? It was about like adoption, it was about inheritance, it was about everything, all those benefits that are linked to marriage. And I've argued in the past how an approach that only focuses on the Special Marriage Act ignores this interconnectedness of Indian family law, right? Because neither there's, in the absence of a uniform sort of secular code, all family laws remain interconnected. So you cannot talk about one law without talking about the other law. And I think this came out really well in the hearings where the government kept pointing this out. And the court was really conscious of this. So it was very conscious of going into this thicket of family laws where if it changes one thing, there is a domino effect across laws. And I think that's the other way of understanding why the court was hesitant in this case about, going into family law. And the other is perhaps, I mean, just a refusal or a genuine, this as in perhaps not a refusal, and I wouldn't call it prejudice, but perhaps a sense that this was too early. And I think, and this the court keeps saying this again and again, and it compares itself to Fori, the South African Constitutional Court's decision, or for example, even Obergefell. Like all these cases came at the heels of decades of family law litigation on LGBT rights. In India, we just did not see lower court action on these issues, right? We straight went to a Supreme Court decision on marriage equality, as opposed to, a series of like lower court decisions at more incremental aspects of family law. Perhaps if those existed, maybe the court would have been more convinced that this was something that, it would have felt more comfortable doing. But this is at this point, we're just hypothesizing that. But I mean, I think all of those things together contributed to the court's hesitance in declaring these rights. And I think the other way of understanding this is that Indian family law has always had a complex relationship with constitutional law, right? So, for example, Indian family law has long seen controversies about subjecting family law to constitutional rights claims, and it goes back to Narsu Mali, which is a decision of the Bombay High Court. And the court has always been hesitant. And while that hesitation has largely been about religious-based personal laws, in this case, it also extends it to secular law because the secular law itself is interconnected with religious-based personal law. And in fact, Justice Bhatt keeps saying this in his decision where he says the family exists before the state. And therefore, the state only has limited regulatory powers of the family, and the court really can't exercise fundamental rights, review over family because it's an extra legal institution, which Justice Chandrachud obviously disagrees with. And I think this disagreement between the majority and the minority opinions is really the heart of the disagreement in Indian family law. And I think this case is basically telling us that if we want to think about queer inclusion in family law, we need to think about family law holistically, as opposed to, just one aspect of it, which is queer inclusion, because all these issues are interconnected. These are the same conflicts that have played out between, women's rights and constitutional, as in religious freedoms and, retaining religious personal laws that are now playing out in the context of secular family law and LGBT rights. So none of this is new in that way. This goes back to this long-standing debate within family law, I think, which was sort of, which the court sort of reproduces in its own reasoning with the marriage equality. And I mean, and a lot of this is also sort of not very, isn't, if you think about it more logically, it also makes little sense, right? Because at some point the court says that it can't declare a right to marry because if it's a statutory right, it's a statutory created social institution, therefore it's not based on constitutional values. So therefore it's nothing, family is not something defined in the constitution. And I think Shubhankar Dham wrote about this recently, that what if the government was to repeal the Special Marriage Act tomorrow and it would say that there's no intercaste or interreligious marriage anymore? Would the court then say that, oh, in the absence of this law, there is no fundamental right to interreligious marriage? Like, but this reasoning in Supreme, the court would say that if the government were to repeal, the legislature were to repeal Special Marriage Act completely, the court will have no way to say that, there is a fundamental right to marry. So I wonder what the logical consequences of this decision are, which then make you think that, this is a broader problem of subjecting the family to constitutional claims. Or perhaps the court was just hesitant that queer families are just not as visible in either the legal domain or, socially, and therefore it refused to intervene. But yeah.
So thanks for that response. I want to ask a follow-up about your point about there has not been a lot of litigation when it comes to queer inclusion in family law in India, because as far as I have read cases or I've come to know, there have been mostly injunction orders against runaway couples. Those kind of cases are coming. But with now the Supreme Court deciding that queer couples don't have a right to marry, do you think litigation at the lower levels now can help? Because one of the other criticisms about the litigation process of Supreme has been that perhaps lawyers didn't coordinate. Some of the lawyers involved in the case didn't know that the case was starting or the petition
Yeah.
had been filed. So litigation at that level around this time wasn't coordinated enough. But what do you now see as the future of what happens after Supreme now?
Yeah, no, that's a really good question. Thanks. And I think it's sort of, obviously it's hard to predict, right? What these trends would be. And like there's one, obviously the negative impact, which I can talk about first, and then I suppose the positive impact. I mean, the negative impact is that it's obviously hard for any lower court to talk about constitutional rights once the Supreme Court has given such a decision. It's after all coming from the Supreme Court, right? So it has to be reconsidered by the Supreme Court. So, I mean, at least constitutional claims before high courts, etc., would be very hard to bring now once you have a decision like this, which is so clear about, about rights claims, about rights not lying for queer family recognition and things like that. So those would obviously be very hard to bring about. And again, getting this litigation again before the Supreme Court is hard because it's a 5-judge bench. If it has to be reconsidered, it has to be by a higher judge strength bench, which is again very unlikely in the next 10 years. I mean, maybe it'll take, I don't know how much time it can possibly take, but it's hard to sort of predict that sort of a thing. But I think you're right. I think litigation strategies that focus perhaps on statutory interpretation or look at other parts of family law and try to sort of, focus on specific aspects of relationship recognition might help. And we kind of saw those things happening in the US, for instance, where, through the 70s and the 80s, you saw these cases around, they used to call it the lesbian baby boom, where you had a lot of women having like children, either who were formerly married to men or just like two women bringing up children together. And one of them was a biological mother and the other was a non-biological mother. And the non-biological mother going to court claiming, rights over the child when the couple had broken up. And this generation of disputes basically forced family courts to sort of confront questions of LGBT families, because there were two people who had relationships with the child whose marriage was not recognized, and the court and the child had a relationship with both of them. So the court had to come in and say that to preserve the best interest of the child, you would recognize relationships with the non-biological mother who's not a parent. And perhaps you could see such claims coming up. And I again think it's also because we just haven't seen these queer family cases coming up. And perhaps it's because we don't see so much queer family formation and that leading to litigation. And all of this might change as more and more queer families come out, as more and more people come out, form families, which leads to legal claims. And that's the thing with law, right? Things only happen when there are disputes. So I suppose we have to wait for disputes to come up for these things to happen. But that could be a potential way in which lower courts, even family courts, have to deal with such questions, because if people disagree over child custody, somebody has to resolve that, right? And family courts are used to deciding fact specific cases. So that could definitely be a potential sort of thing. And perhaps there are other spaces, maybe other laws to challenge, maybe not, other materially linked benefits, for instance. So for example, in some places, people argued that, people who are in long-term relationships, they're very similar to marital relationships. So so there is no reason to, discriminate against them just based on marital status for, say, for material benefits like, civil registration or pensions and things like that. And that could be a more incremental, smaller litigation strategy that could potentially come up. And obviously, the other angle could be just federalism or, talking to local legislatures. I mean, I don't know how well that works in India, because family law has always been union sort of, it's a national thing right now, even though it's in the concurrent list. We have these national laws, and very few states have like certain specific amendments to those laws or have like changed certain parts of the laws applicable to their states. But largely, we have these large scale family laws. And I also wonder, with like debates about the Uniform Civil Code moving to states. So, for instance, the recent, Uttarakhand coming up with the UCC. What does that mean for like family law going forward, right? Because if that really solves all these problems of institutional legitimacy, because if you replace all personal law with a uniform code, then you have no problem of interconnectedness and dealing with various laws. You only have one law which you can declare unconstitutional in that particular state. And then you can bring a fresh challenge to the Uniform Civil Code before the Uttarakhand High Court and challenge that. And that's a new case, and that's perfectly valid and is not affected by this case at all. So So, I mean, I feel like there are weird convergences and divergences coming up based on what the trajectory of family law change is going forward. But I think at least constitutional strategies would be very difficult because a Supreme Court decision is obviously very hard to, only the Supreme Court can, again, reconsider it. So high courts won't be able to do that. So you would have to come up with more innovative strategies around statutory interpretation and things like that, I suppose.
That's really insightful, Akshat. And my next question for you is about like before Supriyo, Navtej and Naz were criticized privacy, right? Now, Supriyo adds the logic of separation of power when it comes to recognizing queer relationships.
Yeah.
What do you think this does for the general vocabulary or sentiment in adjudication of queer rights? Do you
Yeah.
think we need to change how we legally talk about institutional exclusion?
Yeah. So, I mean, I personally think that whatever critiques of privacy aside, I think maybe bringing up separation of powers is a good thing, right? I think the queer movement should deal with separation of powers because I think it's at the heart of Indian constitutional design or Indian institutional structure, or what is the relationship between the legislature and the executive. And I think in India, we've had this tendency, and especially India's human rights movement, or most rights-based movements, to focus on the court a lot. And a lot of our change is court-centric. And obviously that comes from the fact that we believe that courts are more likely to deliver progressive change as opposed to legislatures, considering legislatures are majoritarian and are unlikely to sort of listen. But I think we might sort of rethink some of that stuff. And while obviously it seems really hard that legislatures can come in and do these things, ultimately you will need legislatures to come in and do these things, right? Because the courts can't give you these rights anyway. Even if, so one of the reasons, I mean, I've always maintained that even if the court had given a positive rights declaration, you would have still had to have a long political struggle to actually realize these rights. I mean, it would be so hard to actually implement a right because family law is so granular, right? It requires all these multiple changes to happen that courts are simply institutionally incapable of making. So you would have had to engage more politically with legislature, with say political parties to effect those changes. So I think it's actually good to engage with separation of powers. And I think it's a moment to rethink how we talk about human rights, right? And how invested in courts we are, how invested in courts are we when we talk about human rights, even though rights are something that belong to everyone, that belongs to legislatures, that you can talk about rights with the legislature, or the legislature can talk about rights. Similarly, you can talk about rights with the executive. So it's good to sort of acknowledge that constitutional interpretation is not the sole domain of courts, right? It changes through the participation of various sort of organs of the state, including the legislature and the executive. And even though today it might feel that it's impossible to engage with these other organs of the state, but I suppose that's the real challenge, right? How do we sort of engage with these different actors? And perhaps there are like examples, like in Tamil Nadu, they've had the whole, the Madras High Court case, which has led to a lot of dialogue between both the executive and the court about how to bring about LGBT inclusion. And I think trans rights are actually a good example. Like, even though obviously it's not as if trans rights are perfect in India, right? And there is a lot to be done in terms of like socioeconomic empowerment or, affirmative action, for instance, or just like socioeconomic upliftment. But there has been a lot of legal change on trans rights, and largely driven by the legislature and the executive, even though the court started the ball rolling with NALSA. But several state governments have come up with policies, there are boards, there is a law, there are rules, and obviously a lot of it is imperfect. So I'm not saying that all of this is great, and which is good, right? We should critique these laws and we should work towards making them better, but we have them and we have something to work with. So I think it would be important ultimately to engage with all organs of the state to bring about queer inclusion, right? Because that's how things happen. And a court can't unilaterally do any of these things anyway. So I think that's something we should sort of, maybe that's the future of a lot of this stuff. And I don't know if there's an alternate. I mean, also again, how our whole investment in rights, right? I mean, we think of rights as these really important tools of like change, etc. But we should not forget that politics is also equally important, and it's important to keep engaging in it to sort of make change happen. And I think, I mean, I'm still optimistic even after the decision, though obviously it was disappointing, because I think there was such a momentum before the decision that most people felt it would be positive. But I mean, even around us, there is just more visibility in popular culture. There is just more LGBT visibility generally. I mean, in my own, like, I remember even like since Nowadays things have changed so much in terms of visibility and in terms of at least, people knowing that LGBT people exist and they have rights and things like that. So I think that isn't it something that we see more and more of, which is good. And perhaps that's just the way forward. You just need more social consciousness, you need more engagement, you deal with more people. But it does, I think, question, like we are always taught, especially I was in law school, I was always taught that law is a tool of social engineering. And I don't know whether they say that still at NLS, but that's what we were always told. And I wonder if we should rethink some of that, of whether top-down legal change is often useful, or what are the limits of top-down legal change, or perhaps when does top-down legal change happen? And this decision probably tells us about the requirement of certain preconditions for top-down legal change to happen for it to be positive.
Yeah, thanks for that. Coming to our last question, that one's a little more technical than the previous question, but Justice Bhatt sort of says that queer couples don't have a right to adopt because their relationship is not recognized in law. So this logic, do you think exclusion here reproduces exclusion? The sense we see in the judgment about you can't adopt because your relationship is not recognized and the court does not recognize the relationship. Then it talks about its own limits, about what it can do. And then it again says you can't have these rights because, sorry, your relationship is not recognized. So do you think there's a larger sense of exclusion is reproducing exclusion when it comes to constitutional adjudication in queer rights? Do you have any thoughts on that?
I mean, it's certainly a circular argument, right? And then I think perhaps the court also, there were so many claims made in these proceedings that the court also, like, perhaps the court was dealing with a lot, and then it just like all of this together just did not go really well. I would assume that a different proceeding on just say adoption that talks about inter-se relationships. I mean, so how early adoption cases happened in like the US, for instance, was when like second parent adoption was basically recognized by the court. So there was like a queer couple, there was a biological parent, a non-biological parent. The biological parent was recognized, the non-biological parent was not. And the court said that, oh, now this non-biological parent already has a relationship with the child sees the non-biological parent as a parent, there is nothing to distinguish them from any other two parents, so you recognize adoption. And I think those cases work better because you have like a concrete, case in front of you where you can see it. And I think what happened in this case was that since there was so they were already discussing marriage and then they were discussing adoption. And since they said we can't do one, then we won't do the other. And the whole thing just went out of it, I think. So it's something to sort of think about, when can these arguments be successful and when they aren't successful. But I mean, I don't agree with the reasoning, obviously, because I think it's circular and it makes no sense. But I mean, it would be unlikely that they were to give adoption if they didn't give marriage. So I mean, that's the other link between marriage and family law and parenthood, right? So if it was a case about just adoption, you could have made different arguments. But now, once if not given one, you can't give the other. So I mean, that would be inconsistent for the majority to have done. So I'm not surprised with that outcome within this case, considering they already said no to marriage. So yeah.
Okay, so that's it from questions from our end. Do you have anything you want to say? End it on.
No, I think this was great. Thank you so much for having me. And yeah, nothing's really specific about it.
Thanks so much for coming.
Yeah, thank you.
And
Thank you.
Bye bye.
Thank you. Bye.